Hello, I'm Paul Laney, the retired sheriff from Cass County, North Dakota, and the current vice president of national sales for Turnkey Corrections.
And I'm Lauren Matthews, and I'm the current social media and content specialist for Turnkey.
And you are listening to JailTalk, and we are back for part 2 of a very informative session. We have with us Rick Hodsdon. He is the current general counsel for the Minnesota Sheriff's Association and also wears a plethora of other hats. He teaches for the School of Staff Command from Northwestern University, teaches for the National Staff Command College, heavily involved with the National Sheriff's Association. In fact, that's how you and I first met years ago, was through all your roles. And we are just very, very blessed to have you with us. As I said, I know your schedule, and I kind of called and almost begged him, hey, can you come share some of your knowledge? And what was really cool, he said, of course. So thank you for doing that, and thank you for taking time out of your crazy schedule. You're supposed to be retired, but I've also learned you have no idea what that word means.
No.
So we know we're blessed to have you here. And in part 1, we really were able to give our listeners some really good ideas. We're talking like civil action cases and civil liabilities within the jails, and you hit a lot on 1983 and all that. And for our listeners, if you have not listened to part 1, please go back and listen to part 1. And while you're going back to look, give us a like, give us a follow on YouTube. We're really excited about what we do with the show, and the more support we receive from you, the stronger the show gets every time. So with that, can I kind of maybe ask you just go back to part 1 a little bit and give an overview of what we talked about?
Yeah, we focused particularly from a civil liability standpoint for government officials on so-called civil rights actions or 1983 actions named after 42 U.S.C. United States Code Section 1983. And for a plaintiff to sue on a civil rights case, they have to show that you acted under color of law as a defendant. They have to show that you violated either willfully, intentionally, recklessly, or the other term, which we're going to get into more in this session, with deliberate indifference, violated someone's constitutional rights and caused them to suffer some kind of harm or damages or to be entitled to injunctive relief. So that's a quick overview. I recommended one of the strongest things you can do in corrections in a jail is have a viable, effective grievance system. It's a pain in the neck, but yet, according to the federal government, it prevents at least 5,000 lawsuits a year from being filed. And many of them that are filed, the plaintiffs lose because you've already addressed many of these issues with your viable grievance system.
And I would say this might sound like common sense, but not only have it, utilize it. You can't just have it on paper and not utilize it. You've got to be able to show the court that you follow through with what you say you're going to do with these. My grievance system, we had where it started with the deputy in the pod, and it worked its way through and ultimately could end up on my desk. And I think obviously from your chair, you're going to say, yeah, it was great you have one on paper, but you've never followed it once. You're not protecting yourself then, correct?
No, absolutely. The United States Supreme Court has had many, many cases involving the Prison Litigation Reform Act and the grievance system. And they've made it very, very clear that if you have a viable, effective system and use it and have communicated to the inmates, even if they choose not to use it, you still win. But you're absolutely right, Paul. If you have it on paper and the Supreme Court determines or a court determines it's a sham, it's a fake, then the grievance system isn't worth anything. So it really needs to be a functional, viable system. And you really also want to make sure you're keeping records over time. You should have, I would strongly encourage you to have a record of every grievance that has been filed. So if you're called out that it's a sham viable, and you say, no, last year alone we handled 500 of them. That doesn't mean that the inmate prevails. Maybe they win 1 out of every 100. But at least if you can show you're really using it, that's the solid defense.
Well, excellent advice.
And one thing you touched on last time, and one thing that kind of stuck with me and I think is important, is you talked about how, someone like a jail administrator is liable for something they do, but they can also be liable for something their subordinates do. So can you kind of go more in depth on those types of situations?
Absolutely. Not only can you be liable for something a subordinate does, you can be liable for something that a colleague does, and you can even be liable for something that a boss does under the different theories. In order to be liable, employers, for example, in a typical civil lawsuit, a tort claim lawsuit, there's a legal doctrine called respondeat superior. So if I, for example, I often use as an example when I'm teaching for Northwestern. If I decided to own a Jimmy John's franchise, and I wanted to hire Ed to drive freaky fast to deliver those sandwiches, if Ed's driving freaky fast and blows through a stop sign, even if I've trained him, I've educated him, I've done all the things I need to do, I'm going to be liable as Ed's employer under the doctrine respondeat superior. He did something negligent and it's reasonably foreseeable, so I'm stuck with liability as the employer, even if I didn't do anything wrong. The United States Supreme Court has said that doctrine doesn't apply to civil rights cases. That to be liable for a civil rights case, you have to be the one who engages in the constitutional violation. And you can do that by intentionally or recklessly engaging in a constitutional violation. So let's say I'm a jail administrator and I wrote a policy for my jail that was a violation of the Constitution. I permitted corporal punishment. Decided, okay, we're going to, it worked for my kids. They stopped misbehaving when I started spanking them, so I'm going to write a policy that allows my staff to engage in corporal punishment as a consequence for jail misbehavior. That's clearly an unconstitutional policy, and so if one of my staff follows up on it, that staff member is going to be liable for violating the inmate's constitutional rights, but so am I for having the policy. And that policy could be a formal policy or it could be a custom or practice. And even employers can be held liable if they have an unconstitutional policy, custom, or practice that leads to a constitutional violation. So, for example, there's a case out of Texas a few years ago where the Fifth Circuit Court of Appeals affirmed liability for accounting because, according to the court opinion, they had a quote, bizarrely high rate, unquote, of staph infections. And the jail administrator, the sheriff, the medical director at the jail had repeatedly been advising the county commissioners, the county board, that they had a medical problem, that they were worried about safety of the inmates, the safety of the staff, and they needed the X, Y, and Z resources to address this issue. The county board made the decision not to spend the money on it. And ultimately, the Court of Appeals held, because you have to look at what did you do wrong. And they looked at the jail administrator, looked at the sheriff, looked at the medical director, and they said, you folks didn't do anything wrong. You did everything you possibly could with your resources, and actually held the county board liable for its decision. And so that's one way to be held liable. Now, how a supervisor or even a coworker can be held liable for the constitutional violations of a subordinate or a colleague is typically the doctrine of deliberate indifference. So if you are deliberately indifferent to the risk, for example, that a subordinate would engage in constitutional violations, and they actually do it, then you can be held liable directly to the victim. So we've seen many cases, for example, of sexual misconduct, sexual abuse of an inmate. All 50 states make sexual misconduct and a staff member toward an inmate a crime. And from a civil liability standpoint, the offending staff member they have no defense other than it didn't happen. Consent is not a viable defense, civil or criminal. But then the question becomes, if I've got a staff member who engages in sexual misconduct with an inmate, why is that on me as the jail administrator? And the answer is, if I did not take reasonable measures to reduce the risk of that behavior, if I didn't train, if I didn't write policies and procedures, if I didn't strictly enforce the law on misconduct, if it can be shown that I didn't do those requisite things as a supervisor or manager, then when the staff member engages in the sexual misconduct, I'm going to be liable under the deliberate indifference theory. And we see this in inmate-on-inmate assaults. If I know that a person is at risk, I'm the sergeant in charge of the pod, the inmate tells me that there's a bunch of gangsters that are threatening him. I have reasonable basis, if I investigate it, to find out that's true. If I don't do anything to protect that inmate, isolate them, move them, protective custody, whatever, and they go ahead and get injured, then as a rank and file staff member, I can be deliberately indifferent and found liable on that basis. So it isn't just bosses or supervisors that run the risk of deliberate indifference. Like I say, a line staff member can be held liable in that same theory. And the same thing applies if you have a coworker who you have reasonable basis to believe is violating somebody's constitutional rights. You don't have to take extraordinary measures. You don't have to put yourself at injury, but you do have a duty to act and to take reasonable measures to intervene. That's not unique now. These cases historically came up a lot more in the jail, but if you look at the so-called police reform movement going across the country, you'll see more and more. Minnesota, for example, last year specifically passed a statute, and many other states are doing it as well, where the statute basically says, regardless of your rank, position in the organization, the perpetrators, if you believe that a coworker, even if they're your boss, is violating somebody's constitutional rights, you have a duty to take reasonable, proactive measures to intervene. And that's very much a strong national trend in the jails and on the streets. In this Minnesota, in this most recent session law, amended the statute to provide the same thing in the area of corrections, that you have an affirmative obligation, and that's going to be a really strong signal from a civil liability standpoint, and now potentially criminal liability.
Right.
So it's an important thing to worry about.
Does it scare you the direction you see things happening across the country? I mean, you have years and years and years of experience. What's your feeling towards what you kind of see happening with a lot of the deliberate indifference? You see a lot of, the media and social media is so much inflamed up the law enforcement world right now. And in some ways, I feel is almost forcing confrontations because of certain things that happen out there. What's your feeling on the direction of where it's going, and what's your advice to our listeners? You talk about the deliberate indifference, but it doesn't even have to be to that level. Even just a negligence or something like that. You were talking off screen about that, and that resonated with me as a former sheriff and as a former jail administrator. That it doesn't have to even be something you just say, "I don't care," does it?
No, in deliberate indifference is a bit higher standard, and we've been focusing on 1983 actions. But as I mentioned in the prior episode, there's also a risk of simple negligence. Negligence is doing something that a reasonable person wouldn't do, or not doing something that a reasonable person would do, that breaches your duty of care and causes harm to another. And in law enforcement, in the jail area especially, we're seeing a whole body of law where maybe what you did wasn't deliberately indifferent, but it didn't meet professional standards. And so the example that I use with some frequency is, inmate on inmate assaults. So let's say you have a classification system, but you're using the old style classification, felony, misdemeanor, male, female, adult, juvenile. That's pretty much your classification system. Well, you're doing something, and that's one of the ways to defeat a claim of deliberate indifference. You do something. So you're probably not going to be liable, unless you're really out there, you're not probably going to be liable for a 1983 action if you have, for example, an aggressive inmate assault another inmate. But you're probably going to be liable on a negligence standard, because the jail administrators and corrections folks that are listening know that old style of classification of inmates is old school. It's the modern system for a long time has been a behavioral-based classification. You folks in the jail industry know some of your most dangerous, violent people might be there on a misdemeanor assault or even disorderly conduct this time. But when you look back and look at behavioral-based classification system, you know they're some of your most dangerous predatory inmates. But if you're not adapting to the modern correctional era using what people call preferred or best practices, you can still be liable for negligence in corrections, even if you're not liable on a 1983. So we're seeing a trend as corrections is moving in away from some of these 1983 cases. A lot of these cases are migrating to state court. Now, I suppose the good news is you're probably not going to be liable for punitive damages or the attorney's fees we talked about for a simple negligence action, but it's still going to cost you a lot of money. In terms of what I'm concerned about from a law enforcement, whether it's on the street or in the jails, one of the big push in some states, they've already done this, and then Congress has been looking at this with the so-called police reform movement, and that is the abolition of one of the strong defenses that we have in the public sector, and that is the defense of qualified immunity. And I'll take a minute to talk about that because this is something to watch very much from a political standpoint and public relations with elected representatives. Qualified immunity is a doctrine that was created by the United States Supreme Court. And qualified immunity, to understand it, and very few politicians in my experience do, even the ones that are voting to repeal it don't really understand that, unfortunately. Qualified immunity was created by the United States Supreme Court, and they went back to the initial purpose of why the civil rights law was passed in the first place. And they looked back and said, back in 1871, Congress passed this law with the purpose of giving people remedies and therefore trying to deter intentional, reckless, wanton, willful misconduct that rises to the level of a constitutional violation. And so the Supreme Court said, applying that standard, well, then what if you violated somebody's constitutional, or you did something, and a court later said, well, you're not supposed to do that anymore. That was a violation of the Constitution. Well, why would you be punished? It's almost like a civil liability ex post facto. The Supreme Court had never said you can't do this or you must do this. They haven't ruled on it. So why would you impose liability on a government official simply because what they did at the time, nobody told them not to? Now, once the Supreme Court issues a ruling and says you can't do this, this is a constitutional violation, fine, now you're on fair notice. Then don't do it anymore. But until they issued a ruling, why would you be held liable as a government official because you acted in good faith trying to do your job? And that's an area that I have apprehensions about because I say there are people in Congress who want to abolish qualified immunity, which means you do something and a year later Supreme Court says, well, those things aren't supposed to be done anymore, but now we're going to impose liability on you for something that we had never ruled on before. So that's one of the concerns that I've been working with, as you mentioned, Paul. I do a lot of work with the National Sheriff's Association. We have a legal advisor group, and we've been working very strenuously with position papers and arguments about why qualified immunity is really important to law enforcement. And remember, it's not just law enforcement. All these doctrines, as I mentioned in our last episode, apply to any government official. You could be a social worker, and if qualified immunity is abolished, you remove a child from a house because you thought that was a good idea for the child's safety. A year later, a court says, well, not under these criteria anymore. You now have liability exposure for removing that child in good faith on what you thought was constitutionally sound grounds. It turns out later it wasn't. So it's a big deal.
Well, it is scary, and I think for any of us that are in that business of dealing with humans and human behavior, you go in with your best intents, and now to find out that you might be hung out there is scary. And I think something that every law enforcement leader needs to tune into, not only to protect yourself, especially to protect your people, and be vocal and be and talk with fact and be working with your state associations and because there's a momentum happening in this country right now that's kind of scary, and some of it the momentum isn't always based on fact. It's based on hype, and it's got to be about fact. And one of my questions I was going to ask you was, who could be held liable, and you really summed it up. Anybody and everyone who touches it, if you work for that agency, and you really, I think the answer is, if you're even anywhere near close to this, you could be held liable, so you have a responsibility to make sure it's being done right.
Absolutely. You can be, hundreds of miles away from an incident, and nevertheless, you can be sued. Now, you can be sued for anything. That's an easy one. The easiest question, lawyers shouldn't even, I know it's terrible for me to say, but lawyers shouldn't even be allowed to charge a fee for answering this question, because the question's, can I be sued for? The answer, I don't care what the rest of your question is. The answer is always yes. But what we want to do is try and reduce the liability exposure. Right. And we have a lot of people who end up getting sued that a plaintiff or a plaintiff's lawyer has no intention of ever thinking they're going to prevail on them, but at least not if they have to go to trial. But nevertheless, there is that liability exposure. And the other scary part of this whole discussion I've just had now about qualified immunity is there is a criminal counterpart, which many of us have forgotten about, to 1983 actions. People can be criminally prosecuted through the federal court system for criminal violations for 1983 actions, type actions as well, violation of someone's constitutional rights.
And I think isn't that what happened with the Rodney King situation?
There was, and that's what's happening right now in Minneapolis. We have 4 officers who have been charged in state court, 1 convicted, 3 pending, but they also, the feds have indicted them as well. So there are multiple layers of this discussion, and there are those in Congress who want to make it easier to criminally prosecute government officials as well for an alleged constitutional violation, which is one of the reasons it's critically important. One of the defensive tactics I'll urge and advocate in this session is it's critically important for everyone who works in law enforcement. Our focus today, of course, is law enforcement, jails, corrections. It's critically important to have a good, sound grasp of constitutional principles. You absolutely need to have some kind of a connection. Either if you're big enough and you have your own counsel as an agency, they should be paying attention every day to any rulings by your Federal Circuit Court of Appeals and U.S. Supreme Court for sure. If you're not that big, many sheriff's offices and jails are pretty small. They don't have that dedicated resource, perhaps through your state sheriff's association or some resource, because the critical issue of qualified immunity isn't your personal knowledge. It doesn't make any difference. I didn't know. I never knew the Supreme Court ruled on that. Too bad, so sad, pal. It isn't what your personal knowledge level is. It's what has the court ruled. It's an objective standard in that sense rather than subjective. And the day the Supreme Court issues a new ruling, for example, on search or seizure or something like that, whether it's in a jail or on the street, that is the new law of the land. So something that was legal yesterday is now a constitutional violation. And sometimes those can change pretty drastically. I remember when the Supreme Court issued a decision in 1980 called New York versus Belton. The cops out there will remember that search incident to arrest, where the Supreme Court said, if you arrest somebody in a car, you can search the entire interior passage or compartment of the car and any containers in it. That was constitutional law as far as we knew from 1980 on. And then along comes a case in 2009 called Arizona versus Gant, where the Supreme Court said, well, we didn't really mean that. We kind of changed the rules, but they didn't want to admit they changed the rule. Well, the day Gant came down, that means that you arrest somebody in a car. If you search it pursuant to the Belton standard, you no longer have qualified immunity because the Supreme Court ruled on it. So I remember that case vividly because the morning it came out, I think it was a Tuesday morning. By that afternoon, because the Minnesota sheriffs have an incredibly brilliant lawyer, every sheriff in Minnesota had a memorandum to tell them the rules have changed. You guys, your folks have to stop doing that. So then the sheriffs had to get, and chiefs of police had to get out brand new post orders directives in order to reduce that liability exposure. That's how rapidly these things can change in the modern era, and you don't get a grace period anymore. That's what the law is.
Well, I remember that well. I've been a sheriff 2 years, and when that new ruling came down, and I had operated, I'd been a law enforcement officer for 18 years, and I'd searched a lot of cars incident to arrest. And all of a sudden, it's like, whoa, what do you mean? And I remember that well because it changed how we did things. And again, it went back to, well, we better get this done because now we're liable.
And if we didn't have the defense of qualified immunity, that means going whatever the statute of limitations was for all those searches you did up to 2009, you would have been subject to liability exposure.
Absolutely.
And as I said, liability exposure for compensatory, punitive, and attorney's fees.
Well, and that duty to train it, because I might be in bed at 3 o'clock in the morning and one of my deputies does that illegal search. Going back to what you said before, it doesn't matter. I'm on the hook now, as is my agency, as is my county, as are my taxpayers.
Absolutely. So that's why, like I say, it's critically important to have somebody for your organization paying attention to these issues.
Mm-hmm. And you said, I didn't know isn't an offense. So how do jail administrators and sheriffs, what is the best way for them to stay on top of all of it? Because I'm sure, like you said, it changes. It can change overnight, really. So what is the best way for them to stay on top of all of it?
Well, again, if you're big enough and you have dedicated counsel, like a good friend of mine is embedded. He's a lawyer. And he is embedded in the San Diego County Sheriff's Office and has several lawyers working. They're a huge agency, so they can do that. But otherwise, it's some kind of a system. Either have assistant county attorney, your state association, some organization should be in place to try and keep you on top of things. And again, Supreme Court absolutely is a gold standard. You also, however, want to pay attention to your Federal Circuit Court of Appeals, because there are some of the circuits that take the position that, well, even if the Supreme Court hasn't said something's unconstitutional, if we've said it is, then as far as your jurisdiction is concerned, it is. And of course, anybody who follows case law and 1983 cases, I'll be delicate about this, but there's a circuit out there on the left coast that I won't say its number other than it's less than 10 and more than 8, who is infamous for some of its kind of rulings. And in terms of deliberate indifference, cases in which the Supreme Court has overturned, they continue to be the most overturned circuit in the history of the country. But in those, so if you're covered by that jurisdiction, even if the U.S. Supreme Court says there's something you can't or must do, you still could potentially be stuck. So pay attention, Supreme Court for sure, but pay attention to your federal circuit as well. In whatever mechanism, whatever resources you have, because as you said, I didn't know isn't a defense. And likewise, I was just following orders. That didn't work so well for the Nazis at Nuremberg. It doesn't work for 1983 cases. If you've got a boss who wrote an unconstitutional policy or permits an unconstitutional practice to take place, and your defense is, I was just doing what the boss said, that's not a defense for you.
So what is your best advice for staying out of a 1983 situation? We got our listeners down. I bet we've got a lot of their attention. And, you've lived this, breathed this. This isn't stuff. I mean, you've been in the courtroom for years and years and years doing criminal law and understanding this and teaching and training this. In a couple minutes, how can we capture to them the best way for them as a sheriff, as a jail administrator, as a supervisor, as a line level deputy in the field or in the jail to stay out of a 1983 situation?
Well, as I said, you can get sued for anything, so I can't keep that from happening. But from a liability reduction standpoint, a couple key points is, one, somebody needs to be, when is your policy procedure manual done? And the answer is never, because we all know things are changing, best practice, custom. So certainly having a system in place to keep track of all constitutional requirements that relate to your zone of responsibility and activity. Make sure that you're continuously monitoring the case law. Then make sure that policy procedure manuals that you are implementing are updated. Like you mentioned, the Gant change, all of a sudden you have to get a quick word out, classification issues. But beyond the 1983 and keeping those current, you want to also keep track of professional standards. Because you can, as I said, you can avoid a 1983 liability, but if you're not keeping with current professional standards, custom practice, best practices or preferred practices, whatever term you want to use, then you still got liability. You have liability exposure on the negligence theory. And then all the policies in the world aren't worth a bucket of whatever if you're not ensuring your staff are trained in them. It's not like Animal House where you get double secret probation. You have to make sure your people are aware of it, know what the rules and regulations are, and that you've documented, you've kept them current, and that you've trained them, and that they understand it. Those are major ways to reduce liability exposure. For staff misconduct, the courts have repeatedly said a major way that managers, supervisors, administrators, sheriffs can reduce the risk of claims of deliberate indifference for staff misconduct is policies and procedures, training, and then the other key third point that I haven't mentioned till now, and that is thorough, comprehensive background checks to make sure you're not hiring someone with aggressive, violent tendencies. Time and again, we see cases in which, especially for staff sexual misconduct, where the appellate courts have said, it's too bad that this staff member did these things, but the jail administrator, the sheriff, is not going to be liable. And the big three holy trinities of that are training, policies and procedures, and background checks. And that's some of the strongest ways you can avoid liability exposure.
And I think right now, that point especially about the backgrounds and we're hiring, you look across the nation, every agency is struggling to get people right now. Just sign of the times, whatever the case may be. Across the country, we're seeing it harder and harder to recruit young people to come into law enforcement. And that the reason I say that is what makes me worry is that we start settling for lesser standards. And that's exactly what you're saying. You might get that body in the door, but you might be opening yourself up. So do your diligence and stand strong.
I think you have to. The reality is, it's tough. I teach recruitment and selection. That's one of the classes I teach for Northwestern. And, that's a universal problem. They did a survey of law enforcement, people currently in law enforcement, and they were asked if you had a young person, a son, a daughter, niece, nephew, young person is thinking about going into law enforcement, how many of you would suggest they don't? And the answer was astonished me. 89% of current law enforcement officials said I'd try and discourage them from doing that. When you're talking backgrounds, though, I want to encourage and remind, especially you have people who are not custody staff that work in your jails and your prisons. Why wouldn't you be backgrounding them like you would your custody staff, your cops on the street? I did, as part of the pre-op training for law enforcement in Minnesota years ago, I researched every criminal case of criminal sexual conduct in which the person described as the victim was an inmate. And out of this, of all the cases I found, because I could go to the sentencing guidelines and they could pull those cases up, and then I pulled them all, there was only one case involving a custody staff member. The other people were like programmers, correctional health nurses, cooks, the so-called civilian positions. So be thinking about that as well, because you might have a contract for a medical provider, or you may have a contract for a food service provider. But if you're the sheriff, the buck still stops with you. So what are you doing to not be deliberately indifferent that those people might cause harm or injury? So if anything, that's a major area of potential liability exposure in a lot of places in the United States today.
Great advice.
We're coming to the end of part 2. Do you have any final thoughts or advice for all of our listeners?
I think that what we just talked about are, in terms of liability reduction, I do, one, pay attention to the politics of what's going on in law enforcement, criminal justice, understand the role of qualified immunity, and understand how to defeat deliberate indifference. Do things. Keep current, keep active. If you have the chance to be involved in a professional organization such as our State Sheriff's Association, the AJA, the ACA, use those resources. It can be money well spent. And lastly, don't be afraid to talk to your lawyers. I'm not saying that to create full employment for lawyers by any means, but most of us who work in the public sector are plenty busy already. But I have to tell you, if you've got a question, I've been doing this for in excess of 40 years. When somebody, jail administrator, calls me and says, here's what we're looking to do, can you review our policy and procedure? And I go, okay, we tweak this, we work on that. And then if we get sued, I'm far more vigorous in defending that policy now because I had ownership in it. We lawyers have a bit of an ego, as opposed to a jail administrator comes and says, I probably should have talked to you about this before, but we just got sued today for X. I go, oh, sure. Thanks a lot, guys. So, use your legal resources. I think it's one of the strongest things because we'll fight a lot harder for you if we're part of that decision-making process.
Well, great advice, both part 1 and part 2. And to all of our listeners out here, as I said, Rick is just a plethora of information, and we're really excited to bring his knowledge to you. Will you come back again sometime
Sure.
down the road? We'd love to have you back. Everything you talk about is so valid in the world that we're in now. And again, our goal is always to bring them in up-to-date information from the best of the best. And we had one of them sitting right here today. So thank you so much for your time.
Absolutely.
And for your expertise. We really appreciate it.
Mm-hmm. And thank you, everyone, for tuning in and listening. Make sure you subscribe to our YouTube channel, follow us on Twitter and Instagram, or email us at jailtalkpodcast@gmail.com.
I'm Paul Laney.
And I'm Lauren Matthews.
You've been listening to Jail Talk. We'll see you next time.